Tusikilize kinachojiri kwa sasa.
So according to Mr. Nyamondi, before the order of habeas corpus was issued, the first and second respondents should have been heard. He maintained that the allegations were that the second to fourth petitioners were missing, but the court ordered that they be produced. He told the court that one of the first and second respondents' possible responses could be that the first to fourth petitioners are not in their custody, and urged the court to allow the application. I have considered the application and argument by parties on whether or not to set aside the orders issued on 8th of January 2025. The first and second respondents' argument was that they were not served with the application and the orders because the email addresses used were not their confirmed email addresses. Further, that the affidavit of service did not contain evidence of service, namely a delivery notice. The petitioners maintained that the first and second respondents were served with the orders and application. From the affidavit of service sworn by Mr. Noel Odiwar, one of the petitioners' advocates, on 13th on January 25, service on all respondents was done by email. The affidavit of service listed the email addresses used to effect the service. The list of email addresses the list of emails appeared in the order of the parties. The first and second respondents were served through the email npsnationalpoliceservice.go.ke and the director at dci.go.ke respectively, which they have disputed. Director at CID, not the DCI, which they have disputed, arguing that those email addresses are not their confirmed email addresses and therefore they could not have been served. They relied on Rule 22, Sub-Rule 5, or Rule 22B of Order 5 of the Civil Procedure Rules to argue that the rule requires service by email to be done through the confirmed email address of the person being served. Rule 22, Sub-Rule Rule 22B provides as follows. Summons sent by electronic mail service shall be sent to the defendant's last confirmed and used email address. Service shall be deemed to have been effected when the sender receives a delivery notice. An officer of the court who is duly authorized to effect the service shall file an affidavit of service attaching the electronic mail service delivery receipt confirming service. The rule requires service. That's the end of the quote. The rule requires service by electronic mail to be sent to the defendant's last confirmed, underlined, and used email address. My reading of the rule is that the last confirmed and used email address refers to a situation where parties have been in communication through email prior to filing of the suit, so that service will be effected to the last used email address in such communication. The last used email address is deemed to be the confirmed email address. However, where there has not been communication between the parties, like in this case, there cannot be the last confirmed and used email address as required by the rule. That should not mean a party cannot be served by email as long as the party serving demonstrates that the email address used belongs to the party served, or the party served can be found through the email used. A strict reading of the rule would make it impossible to serve a respondent, thus defeat justice. Where the email address is doubtful, the rule provides for other modes of service which can be resorted to. Service by email should not be attempted unless the party serving is pretty sure that the email being used belongs to the party being served. In this case, the first and second respondents, as the petitioners correctly argued, are public officers holding public offices whose contacts, including email addresses, are publicly available. It is not necessary that there should have been communication between the parties so that there can be a last confirmed and used email address. The publicly available email address can be used as long as it belongs to that office, officer, or the institution being served. Mr. Nyamoti argued that the first respondent is established under a different article of the Constitution from that establishing the National Police Service. In his view, the first respondent could not be served through the email belonging to the National Police Service. Though an attractive argument, it is not convincing. It is unconvincing. It is true that the National Police Service is established under Article 243, while Article 245 establishes the Office of the Inspector General of Police of the National Police Service to exercise independent command of the National Police Service. That is, the Inspector General is the overall head of the National Police Service. Although established under different articles of the Constitution, Inspector General cannot be linked from the National Police Service because he is the head of the National Police Service. In that respect, service through the email of the National Police Service cannot be disregarded, since there is no doubt who the Inspector General of the National Police Service is, being the head of the service. The decisions relied on by the first and second respondents correctly capture the essence of service, which is to bring to the attention of the person sued the existence of the suit and give him or her an opportunity to respond and defend himself or herself. Where service has been done through the email of the National Police Service, the service cannot but bring to the pleadings to the attention of its head and the commander. I am not persuaded by the first respondent's argument that the email address used was not his confirmed email address or that he was not served. Similarly, the second respondent is the head of the Directorate of Criminal Investigations. Pleadings were served through the email address of the Directorate that the second respondent heads, and the Directorate had an obligation to bring to the second respondent's attention as the head and the person sued the document served. I am equally not persuaded that the email address used was not his confirmed email address or that he was not served. The first and second respondents further argued that the affidavit of service did not attach a delivery receipt as required by Rule 22, Sub-Rule 2. I have read the affidavit of service, the affidavit in support of the application. I have read the affidavits in support of the application. There is no deposition that the pleadings served through the emails were not received. The quotation was that the email addresses used were not the last confirmed email addresses of the first and second respondents. The first and second respondents can only raise the issue of delivery receipt where they admit that the email addresses belong to them, but deny receiving the emails forwarding the pleadings. Mr. Otiende, SSP, deposed that he is the Director of Legal Services at the National Police Service, but did not deny that the service received the emails forwarding the document. Similarly, Mr. Muga, AIGP, deposed that he is the Director of Legal Services of the second respondent. He did not, however, deny that the Directorate received the documents. In the replying affidavit, Ms. Muturi deposed that the first and second respondent had on a different occasion been served with pleadings in petition 714 of 2024 through the same email addresses, but did not raise the issue being raised now, yet they are represented by the same counsel in both petitions. Such deposition cannot be neglected because it confirms the email addresses last used to serve the first and second respondents. The pleadings were received, and that is why they are represented in court in that petition. Where service is done through the same email address that the first and second respondent had been served with through previously, they are stopped from changing positions to allege that those email addresses are not their last confirmed email addresses. In the circumstances, I am persuaded that the first and second respondent were served with the application and the orders issued on 8th of January 2025. Regarding whether or not to set aside, the first and second respondents urged the court to set aside the orders issued on 8th of January and reinforced on 13th of January. The reason advanced in seeking to set aside the orders is that they were issued without hearing them. This, the first and second respondents argued, denied them an opportunity to be heard and amounted to condemning them unheard. It also violated their constitutional right to a fair hearing. The petitioners countered that the court had jurisdiction to issue the orders that would enforce the Constitution, and the first and second respondents were given an opportunity to appear before court. This court was moved under urgency through an application and petition dated 8th of January 25. The application and petition alleged that the second, fourth petitioners who were arrested by plainclothes police officers on 16th of December 24 and bundled into an unmarked vehicle had not been presented before any court or released. Their whereabouts were unknown and their families' effort to trace them had come to nothing. So were the reports made at Mlolongo and at the River police stations. The petitioners sought, among others, an order of habeas corpus directing the respondent to produce bodies of those petitioners before court. They also sought an order directing the first respondent to appear before court and explain the whereabouts of the second, fourth petitioners. The court considered the application and issued a conservatory order directing the first and second respondent to immediately and conditionally release those petitioners. The court issued an alternative order of habeas corpus directing the first and second respondent to produce bodies of those petitioners in court and assigned a return date for that purpose, being 13th of January 25. On that day, 13th of January 2025, only the fourth respondent attended court. The rest of the respondents did not attend, and all the orders have not been complied with. The court then set the matter for further directions for 17th January and reiterated the orders issued on 8th of January 2025. On 14th of January, the first and second respondent filed this application seeking to set aside those.
Na mtazamaji, tutakuwa tunaendelea kufuatilia vikao hivyo kwenye mahakama ya Milimani kuhusiana na visa vya utekaji nyara, alafu tutakuwa tunakujuza hapo baadaye. Sasa tuzamie taarifa hii ambapo Wakenya hasa wagonjwa